So this is the second session in this afternoon. And in the previous session, we had a very lively discussion of director's duty in the context of insolvency. And in this session, that will be squarely on director's duty in the context of ESG. So it's a nice continuation of the previous discussion. I have to confess, I have not had a chance to read your paper yet, so I will refrain from making any comments on this. But fortunately, we have an expert here today to comment on your paper. So without further ado, let's welcome, how should I pronounce? Arjya, okay, thank you. Okay, Arjya, okay.
All right, thank you very much, Professor Huang. The good thing about following up on that previous act is that you're already woken up and I don't have to we don't have to wake you up any further. All right, so my paper is exploring an exception to fiduciary duties, which some authors feel violates, well, ESG violates these fiduciary duties. Right? So I'm going to start with Corporations and Trusts 101. Right? We know what fiduciary duties are. I'm not going to spend too much time on this slide. I don't have too many slides to begin with. Right? But generally, if I'm handing over my valuables to you, you better take care of them. The heart, that lies at the heart and soul of fiduciary duties. Right? And over the centuries, led by courts in the United Kingdom, we've developed a body of jurisprudence that tells us what fiduciaries can, and more importantly, what they cannot do, right? And these include the duty of care, the duty of loyalty, the duty of disclosure, so on and so forth. The problem arises when we bring into the fold other aspects of decision making. I'm referring to ESG. Now, what is the problem precisely? When ESG came to the fore a few years ago, I thought, well, this is a great idea, right? I'm personally a big fan of stakeholder theory, right? I think Milton Friedman was plain and simple wrong, right? And at the same time, the problem arose that, look, if you're going to be using ESG values to make investment decisions or making business decisions, then on the face of it, you are violating fiduciary duty. Because fiduciary duty compels an asset manager or a director, and I'm using these two interchangeably because the underlying principle applies to both, right? So whether you're a shareholder who's handed over your money to a board or you're an investor who's handed over your money to an asset manager, both of them are your fiduciaries. And therefore, if they're taking decisions based not just on your sole interest benefit, right, which flows from the duty of care and the duty of loyalty, and if instead they're using values, and you'll notice that I've put quotation marks on values-based investing, then yes, that's a violation. I was talking to Professor Umakant the other day when, after his paper presentation, where he sort of delineated the E from the S and G. And he said, it's easier to deal with the E because climate change is universal. It may not apply to all of us equally. It might apply to Vanuatu more than Nepal, right? Vanuatu would be more at risk than Nepal, right, clearly. But that's universal. The moment you start adding the S, and you bring the S into your corporate decision-making or your investment decision-making, that makes it problematic. So I said, no, this will not do. This is unacceptable. We can't let a few hundred years of British jurisprudence ruin ESG. Okay? So I started looking for the exception. So I asked a very simple question. Are fiduciary duties universal? Now, my company law professor would say yes. And yes, maybe she would be correct. But then I started digging a little deeper. And I came across this book, The Economic Structure of Corporate Law, Easterbrook and Fischel, right? A seminal work. And Justice Easterbrook and Fischel, they look at fiduciary duties as not fundamental to a relationship, but as residual, right? Now, irrespective of how a fiduciary relationship is created, sometimes they're created by law, sometimes they're created by contract, sometimes they're created by the relationship between the two parties. For example, a guardian and let's say a ward, right? But in our case, when we are talking about ESG-based decision-making or ESG-based investing, invariably this relationship arises out of the contract, right? Now, whether this contract is an offer document filed with a securities regulator or it is in the nature of a constitutional document of the company, the basis is that this document remains a contract. Parties to a contract ought to be free to determine what their relationship needs to be. Easterbrook and Fischel argue that where that contract ends is where fiduciary duties begin. So I started looking for real-life examples of this. I found some across the world. I haven't been able to cover all the jurisdictions in this room. Happy to do so in a later iteration, right? It starts, of course, with our seminal case of Regal versus Hastings. Corporate opportunities comes to a director, shareholders ratify and say, okay, you know what, we don't have a problem with that. That was the basis for Regal versus Gulliver. Later codified into the Companies Act of 2006 in the United Kingdom, Section 180, which specifically allows shareholders to ratify violations and breaches of fiduciary duty by a director. We found some similar examples in Australia, where in Hospital Products versus United States Surgical Corporation, we said that the fiduciary duty must accommodate itself to the relationship, placing greater reliance on how the two parties to the contract wanted to frame their relationship than fiduciary duties that applied to them in general. Similar in ASIG versus Citicorp, where the contract can specifically exclude fiduciary liability, right? There are these examples from across the world, including one in Singapore, where in Raffles City, we said that we basically reflected Regal versus Gulliver and said, well, you know what? As long as shareholders ratify, as long as shareholders agree, breach of fiduciary duty should not be a problem. I know this was mentioned by my colleague Survi earlier, but India has a very unique take on this. Much like the UK company law, the Indian company law also allows or enables shareholders to set aside violations of fiduciary duty by directors. Additionally, so it's much like there is a similar provision like Section 180 under the UK company law. Additionally, there's an enabling provision which allows directors to specifically take a look at and work, and this is the actual wording, a duty of care, not just towards members, aka shareholders, but also employees, creditors, and the environment. Fancy that. The duty of care, a fiduciary duty typically issued or extended only to financial stakeholders, is now being extended to the environment by statute. The Indian company law takes it a step further and says, and mandates now, not just enables, but mandates that if you meet certain thresholds in terms of your net worth, your turnover, your return, your net profits, you must set aside 2% of your average net profit over the last 3 years into specified CSR activities. Now, I admit India is one of the few countries to do this. There are many, many ways that this can be gamed and corrupted. It has been corrupted already. Don't worry about that. we're very good at that, right? So we did bring out a statutory provision that mandates CSR as well. The problem with this approach is that, and I think I mentioned this a couple of days ago, is that the section 166, which enables directors to take care of the environment as such, this doesn't work very well with concentrated shareholding. Because in a concentrated shareholding economy, much like many other economies that I see across the room here, the board of directors really is just an instrument of the controlling shareholder, right? So it boils down, so whether or not a director or a board or a company takes into account ESG in its decision making, really boils down to what the concentrated or the controlling shareholder wants. Which then offers a good segue into creating this exception. So what I propose is a mechanism by which we can all agree that at least in some jurisdictions, I haven't explored all of them, in some jurisdictions, fiduciary duties are residual. They're not fundamental to the relationship. The contract, on the other hand, is fundamental to the relationship. It is the contract that sets up the relationship, and in the words of Easterbrook and Fischel, where the contract ends, fiduciary duties arise. We've seen time and time again that principals, whether it's shareholders or it's investors, have been able to dictate or determine what that relationship can be. So we can allow shareholders to deviate from fiduciary duties, therefore enabling directors to take into account stakeholder benefit, right? We can do this in India and the UK. UK because of the famous 172 enlightened shareholder value, right? So what I propose is that if the contract, the offer document of the fund or the articles of association of the company, if they can enable the directors or asset managers to take into account ESG-based investing, this does not violate fiduciary duty. We've seen that this is possible. Courts have upheld the deviations from fiduciary duty as long as there's informed consent. And that is the most important part. And that's the part that most companies and fund managers will stumble across. If I were to put into my offer document that I'm going to be using not just financial ratios, but non-financial means to make investment decisions, immediately the investor will ask, wait, isn't that going to be a problem? Because any underperformance you can pass off as, well, ESG. That remains a problem. I don't have an answer to that yet, but we're working on it, right? Hopefully we'll have some answers at the end of the session, but that remains to be seen. So bottom line, ESG does not violate fiduciary duties if there is free and informed consent by our shareholders / investors. To put it another way, if Vanguard or Fidelity were to take into account ESG when making investment decisions, well, they might want to ask their investors first, right? And as a result, investors or shareholders must be able to acknowledge and appreciate the fact that there may be lowered returns. This might be made a little easier in jurisdictions like the UK and India, where we have actually enabled directors to take into account stakeholders, right? I don't think I've taken up all that much time, but that's about it. Bottom line is that ESG does not violate fiduciary duties as long as the principals have informed consent. Thank you very much.
Thank you for the thought-provoking presentation, and you left a question there And I think that should go to Virginia. Okay, let's welcome Virginia to comment the paper.
I think I'm just going to sit here. Actually, I'm afraid I'm going to start coughing too much if I move. But anyway, I just want to, first of all, say that this is a very ambitious project. For those of you who have read the paper, not only does it put together an analysis of corporate fiduciary duties, which we've been talking about for some time, but also the duties of fund managers, asset managers. And so that's already quite ambitious enough for one paper. I noticed a reference to chapters in the paper, so I'm curious if this might be a book project. I don't know. If it's a book project, I think there might be scope to develop in all of these directions. But in addition to talking about two different aspects of fiduciary duty, the paper also covers multiple jurisdictions. And as all of you comparativists know, that is no small task in a short paper. So there's a lot to work with here. I want to first start by saying what I agree with here, and just to state very clearly that I agree firmly, and I think probably many of us in the room agree with Arjya's proposals in terms of the idea of informed consent being a solution in many of these areas, not only on kind of standard ratification questions or ex ante ex post breach of fiduciary, but otherwise breaches of fiduciary duty, context, that kind of thing. But I want to focus my remarks not so much on the corporate duties side, fiduciary duties, because first of all, I believe these are very distinct areas, and I think they should be analyzed separately. But also, you've heard me talk already about the fiduciary duty point, kind of ad nauseum. So I'm going to focus my remarks on the asset manager side, which I think is really critical. And to be honest, I understood that to be kind of the center of gravity for your paper, because you began by saying that ESG investing is a breach of duty, and so when we're thinking about ESG investing, I think our focus should be on what are the fiduciary duties of asset managers with regard to ESG. So that's where I'm going to focus my remarks, although certainly commentators and others can ask questions on any of this. So with regard to kind of the overall premise, I certainly agree that if statute or the corporate charter, or in the case of fund managers, the contract with the client or the investment mandate and policies of the fund require that the fund manager adhere or take into account ESG factors. Certainly, at least as a matter of U.S. law and fiduciary law, and I'm assuming that this is probably true in most jurisdictions, there would be a fiduciary obligation of the investment manager, the asset manager, to follow the client's directives. So that's in addition to a duty of loyalty and duty of care, as well as other statutory obligations and information disclosure obligations. And so that's certainly true. The second concern that I think Arjya has, and you didn't speak a ton to this, but it's in the paper certainly, is just a general concern about ESG greenwashing and lack of information, particularly with regard to the fact that some ESG investments may underperform their benchmarks. And so particularly green bonds are known for having kind of a greenium. There's a little bit of debate about which kind of bonds we're talking about and how big or how small it is, but there might be even negative returns on certain green bond investments. Again, I haven't recently looked at the research on the empirics on this to see if it's like kind of universally true, if it's in certain classes. And there's a lot of variation now in this space. But it certainly is the case that certain types of socially responsible or impact investments or SRI investments that are more values-driven might in fact underperform a given benchmark. But then the question is, what's the right benchmark for those investments? So we'll bracket that for a moment. But in any event, the two primary concerns that I think Arjya wants to address with regard to ESG investing are the need for consent of the investor to, like, what exactly am I investing in? Am I investing in something that may have lower financial returns but reaches certain other objectives? And then am I really informed about what on earth is this ESG in an ESG named fund? And many of our jurisdictions have been focused quite heavily on that in recent years. Hong Kong, Singapore. Hong Kong requires, like, the regulator has to approve something to be an ESG fund. You can't just go out in the market and call yourself that. You have to be authorized, like pre-authorized by the regulator. I'm not sure that that's required here in Singapore. I think Singapore adopts kind of the approach the US took, which is to create a set of standards. If you want to call yourself an ESG fund, we now have like a names rule. There's more we can talk about that, but the point being is like there's now some guidelines that regulators have set to use the name green or sustainable or ESG, and the EU, of course, has gone to a much more robust approach with the taxonomy and regulation, SFDR, and the UK has just passed the Sustainable Disclosure Regulation for the same purpose to deal with the greenwashing thing. So I think all of us are probably in agreement, almost certainly in agreement with the need for greater transparency for investors and investor protection in the ESG space as there's been increased demand for a huge range of very, very different investment products. And so that I'm definitely in agreement with. But I do want to push back on a couple things, as you might expect. One is the proposition, first of all, that ESG is in opposition with fiduciary duties. Because I think from a risk management perspective, ESG is very much aligned with fiduciary duties, and there's a strong argument to be made that a failure to take account of financially material risks, and again, we might put climate risk in some cases in that box, might be a breach of fiduciary duty under any jurisdiction's rules. There's been a lot of studies done on fiduciary duties in the fund manager, asset manager context to look at variation across jurisdictions. I will say that from the U.S. perspective, there is a Supreme Court ruling that says that the best interest of the client is the pecuniary interest, the economic interest of the client, and that remains the rule in the U.S. today, but that has not prevented the Department of Labor from passing the ERISA regulation after much administrative back and forth, like a tennis match. Every administration it seemed to change, but finally that rule has survived and acknowledged that ESG factors may be considered, certainly if they are financially relevant and in an investment decision, and obviously if the client mandate requires consideration of ESG issues, that an asset manager is obligated then to consider those factors. So that I think fits within the contractual model that you're proposing. So that's a little bit of a pushback. The other thing is I think there's a statement in the paper that ESG regulations require stakeholder impacts to be considered. And that may be true for some ESG products, but I would distinguish the kind of CSR type values-based funds that were specifically to advance ethical or social issues like anti-apartheid, or we're not going to invest in oil and gas, we're going to divest from that on ethical grounds, as opposed to we're not going to invest in that on financial grounds. I think we need to distinguish those. So there certainly are funds where they're impact focused, and will call themselves impact focused, and we'll disclose that. And investors can pick and choose what they want to do with that. But I think the mainstream of ESG is now, again, very much on financial grounds. And so I think it might be helpful to distinguish in the paper when you're speaking about kind of the SRI or the values-based investing funds, as opposed to kind of the mainstream funds like a BlackRock might offer, or that any of our retirement funds anymore might offer, that's incorporating ESG and integrating ESG because of the risk factors. So I did go through the paper and look at kind of the different jurisdictions and the way you map them out. And I think probably in future you can develop a little bit more on what do the different jurisdictions do within the fiduciary duties of asset managers in that regard. Are there any restrictions on the ability to have client consent? I would imagine not. I would be surprised if there were any prohibitions, and I didn't see any prohibitions even on the company law side. Except maybe there was something in India that I couldn't, but I think that was more on the company law fiduciary side. And that goes back to maybe Hui's paper about where there's a statutory default versus a statutory kind of a mandate that you can't deviate from. But I don't think with regard to the asset manager question and ESG investing, I don't think we're going to have any problem. In fact, the underlying law will say, again, if your client mandate directs you to invest in these regard, then you're fine. So that would be something there. There's really 4 ways I can see that ESG investing would possibly breach fiduciary duty. And I think you're primarily concerned about one of them, and I think the other 3 are resolved by existing law. So the 4 possible ways that ESG integration could breach fiduciary duty for a fund manager is number 1, greenwashing. which we've talked about, and I think we agree that we need more transparency, more consistency, and information there. Number two, if the fund manager breaches the directions of the client that are in that client mandate or in that investment agreement or policies of the fund. And then number three and number four, the ones you're most worried about. Number three is a breach of the duty of loyalty, where I, as a fund manager, am allocating the investment to certain funds because they favor my political persuasion or my pet social project or my personal values as opposed to the values that the client might have, non-financial factors that might drive their investment. That's up to them. But I want to invest in this particular investment in this company because they align with my personal persuasion. So you did a great job articulating the anti-ESG perspective from the US and like why we have this backlash. It's all on that concern. But I think that that's already well addressed by our existing conflict of interest rules and the duty of loyalty that applies to investment fiduciaries as a matter of fiduciary law. And then the final one, which is I think the center of your concern, is underperformance on benchmarks. And there I think it might be helpful to look at some of the wider range of investment products in the ESG space as you go forward with the paper, because the screening mechanism is just one. And a lot of the ways that ESG investing works now is by benchmarking against comparable investments. So, I as an investor, I may know that I'm going to get a lower than, kind of benchmark return across if I'm looking across a standard market benchmark. But what if I compare this fund to another ESG fund with similar objectives? I want my financial outperformance there. I want to beat that benchmark. I want to beat that green index. But I want to compare apples and apples because I also care about, climate, or I don't want to invest in oil and gas, or I don't want to invest in some kind of sin stock, whatever that may be at the moment. So I think there's a lot of diversity in investment flavors and investment strategy. Again, whether it's financial, whether it's values-based or whatever. And I think there's a lot of sophistication in terms of benchmarking as well. And so I think investors in this space, whether they're kind of more traditional investors, seeking kind of to ride the ESG wave, or kind of these earlier kind of values investors, I think there are measures out there to get at that. So in general, I'm really in favor of the recommendations that you have, both on the transparency side and on the kind of informed consent side. I think that's really, really helpful. But I think it would be great to kind of tease out the distinctions between kind of the corporate debate and kind of what we can do on the asset manager regulation side, especially as there's so much of this regulation coming online. I'd really be curious to hear your thoughts on that.
Thanks so much for that, Virginia. I completely agree that there ought to be, in the paper itself, there ought to be a divergence between the corporate and the asset manager side. The only reason why I wanted to bring this in is because the underlying philosophy of fiduciary relationships remain the same, whether it's company law or it's securities law. But that point is very, very well taken. Thank you so much, Virginia. I also want to sort of tease out a problem of benchmarking, because traditionally, benchmarks have been based simply on financial performance, right? Again, I'm going back to a point I made earlier today, earlier in my presentation, that financial performance have universal truths, right? And earnings per share is an earnings per share whether it's company X or company Y, right? The problem arises, as you pointed out, where we start using our ethics to determine what constitutes a sin industry and what doesn't, right? That's where the benchmarking might fail.
Wait, can I jump in and just say, so that's where we need the transparency, right?
Yeah.
So like, I mean, if it's a sin stock, it better define what I mean by the, the sin of the moment, and,
Yes,
and that's all in the eye of the beholder.
Yeah.
I certainly agree with you there.
Yeah.
Wow, so many hands.
I think I've got a cough.
Okay, let's start from this table, okay? Okay, Professor Lee.
Thank you. Excellent presentation. And actually, I didn't want to ask any question because Virginia has said everything I all agree. and I think Dan will say something. But I just want to point out one thing is that from shareholder stewardship, we base on long-term benefit, overall benefit. So we don't look at the short-term financial performance but long term, probably, if we put this into consideration, that will be different.
Okay, well, so thank you, Arya, for your wonderful presentation. So I just wanted to ask how your discussion relates with the one by Schanzenbach and Sitkov a few years ago. So they wrote a paper that for fund managers, they kind of differentiate the ESG investing for profit,
Yeah.
and also the one that that would have a lower return, but for public good.
So I did cite Sitkov and Schanzenbach's paper quite a couple of times in my paper. Their primary thesis was what I think Virginia pointed out, that there is that, and I agree with them completely, there is a risk of underperformance. What I'm suggesting is that if you are a 172 enlightened shareholder, right, and if you consent to that underperformance, ESG investing should be fine.
Yeah. So what I wanted to ask is that so many investors, they invest thinking that that will make profit, but many cases that unfortunately they don't.
Yeah.
But that is just failed investment,
but again, that's where the importance of that informed consent comes in.
Yeah. But then would you suggest that for even if fund managers is considering ESG issues in the view that it would make profit, do you still require informed consent for that? And that would cause a lot of issues. Like, for example, our government pension fund in Japan, they do that a lot, but it's impossible to gain informed consent from all Japanese citizens.
True.
So then if you require that, that'll be
chaos.
Kind of chaos. So I just wondered, and I think they do this in this understanding that they are just doing this for profit. So it's all under their they're doing this for their fiduciary duty. So even if it fails, it's just, well, they wouldn't say it's a business judgment, but it's their kind of investment judgment. So I just wondered whether you go, so if you require informed consent for this, it will be much more than people are expecting.
I do agree that getting universal consent is next to impossible. Right. I don't think we can expect universal consent on any decision. Right. But as long as the opportunity is there for investors to choose between ESG-based investing and non-ESG-based investing, I think that choice needs to be given to shareholders and investors.
Yeah, so if that's like mutual funds and you just pick one, then that's fine. But
that's fine.
For others, are you going to suggest like a majority decision or something like that? So I was just wondering.
That's something I'm going to have to think about a little bit more.
All right. Okay. Thanks so much.
Yeah, I'm not going to say anything that new, but just to stress the point maybe that Virginia brought up, I think the underlying logic that the fiduciary duty is both linked to directors' duties and linked to the investment manager, to the ultimate beneficiary, I think is distracting because, even the Raffles Town Club case you put up for Singapore, right? Of course, we all know that directors' duties have developed a very specific life of their own within jurisdictions, right? And so, yes, originally they're based on the fiduciary duty, but if you look at Raffles, right, you can't possibly say that Raffles is saying that you can just ratify any breach. Obviously, a 51% shareholder who's also a director cannot tunnel all the wealth out of the company and then ratify it, right? So that's just to give you a simple example of, of course, the director's duties become very specific on that side. And then I'm not going to go into it now because it takes too much time, but on the other side with, an investment mandate and looking at the investment manager and the ultimate beneficiary, right, that's a whole different ballgame, right? So I think just saying that they're all related to the fiduciary, I think it doesn't really have any intellectual leverage, right? So I think you have to separate, or I would suggest that you would be better to separate them out because they are very distinct issues that I think play out jurisdiction to jurisdiction in quite specific ways that I think it's difficult if you try to put them together.
Thank you. I might be, misunderstanding your point, but I think you're saying, informed consent, it can be sort of, a general type of consent, right? I mean, so we just don't need to, hold the, the directors accountable for fiduciary duties. if the shareholders say this in the constitution of the company. Is that something you're suggesting?
No, it's going to have to be a far more specific
Uh-huh.
consent, right? So what you're
So
probably
is there, my question, I guess, is there, sort of a ex ante sort of, that kind of clause in the Constitution which says, we can just.
So one example of this kind of a clause or this kind of an entity already existing would be a benefit corporation in the United States.
But that's a
where-
very different type of company.
Exactly.
Right? Yeah.
So, but where the company's purpose or the objects of the company offer some social benefit. What I'm suggesting is that the directors or the asset managers are restricted or are told that this is the manner in which you will take decisions, that you will take into account the environmental and social ramifications.
So
of your
that's from the
decisions.
very beginning in the Constitution, right?
That needs to be in the constitution of the company.
Yeah. So I don't know what's the law in UK or India says, but if you look at Delaware law, I don't think that will be possible for a company, for a corporation. Delaware law does allow LLC
Yes.
or a limited partnership to do that, but it's not, you cannot just say we just disregard fiduciary duty for companies. But even if for LLC and limited partnership in Delaware, there is something I think equivalent to fiduciary duties that's called implied covenant of fair dealing and good faith. In many ways, it functions, just like fiduciary duties, to hold the directors of those kind of companies. They opt out of the fiduciary duties explicitly, but the court will somehow bring this thing back to, to that type of, business entities. And another interesting sort of observation, again, based on the U.S. sort of, experience will be, you said, you can let people just choose, right? If you like this type of, companies, you can choose, to invest in this type of companies. But the interesting thing is, in U.S., you can list companies, you can list LLCs, you can list limited partnerships, right? There's, okay. However, we see the vast majority of, business entities listed, public entities, they are the companies that are subject to the very hardcore fiduciary duties. So that seems to me it's a sort of a natural sort of, the choice made by the market, right? They don't like those type of, business entities that's just waive outright the fiduciary duties of their directors, so that we don't see that kind of supply in the market of that type of business entities, even if we say, okay, there may be some investors, they want to invest in those kind of companies. So this is just my, sort of, I don't know. Maybe
I agree. Different jurisdictions will have different sort of hurdles to overcome. The United States in particular is going to be a very problematic jurisdiction, which is why I haven't really gone into it much.
We can talk later.
Sure.
Yeah.
Okay, let's pass on to.
Yeah, I have a question or comment about the difference of fiduciary duty for asset managers and corporate directors, as Virginia already mentioned a little bit. In mutual fund situation, in asset manager situation, you only have one beneficiary, is the investors. So it's very clear that asset managers will fiduciary duty to its investors, beneficiary. That's quite clear, and I don't think that there will be big differences from jurisdiction. But when it comes to the fiduciary duty of a corporate director, I think there are so many stakeholders, like no law in any jurisdiction, even including Delaware, just say that you owe your fiduciary duty to shareholders. Like most of the jurisdictions just say that maybe the company, and there are various interpretations about how you interpret company, as we already talked in our Thursday event. And there are so many stakeholders. So in your last point on the contractual model of obtaining consent, I think that there should be different when it comes to mutual fund versus company, because in mutual fund, it's quite clear. I agree with your approach, but in company context, I think the fiduciary duty is not that simple. Yep, so what do you think?
I don't know if I have one more comment too. So.
I just want to make sure that I understood your comment, that I agree with the statement that directors owe fiduciary duties to the company. That is the position in UK common law and has been echoed throughout other jurisdictions. But how does the company project itself, or how does a company decide whether to give consent or not. It is through the voice of shareholders, right?
Yeah, exactly. So that's where there's a difference from jurisdiction to jurisdiction. So when you talk this to a Delaware lawyer, for example, he would say, okay, shareholder approval is fine because we are not very interested about stakeholders or creditors or employees, maybe. But when it comes to other jurisdictions, I think that should be quite different, whether you have a more stakeholder-oriented corporate law or not. So that's my point. So it makes much complex compared to mutual fund.
I think there's one more question. Right? Okay, this side.
Thank you so much for the presentation. My question is maybe about the point on asset managers, going back to that discussion. And I get the point of giving investors the information in order for them to decide where to invest. That's basic financial consumer protection law. But I was wondering, what are the gaps that you're seeing currently in that type of protection in terms of disclosure in order to propose something additional that seems to go beyond that step, which is asking for consent? I'm worried about that type of requirement in the industry because maybe it will become as a protection that is not as meaningful as we see in data protection, for example. This requirement of asking for consent to everyone doesn't seem to protect in real life.
Okay, how about this? Larry Fink creates BlackRock and then creates BlackRock G or BlackRock Green. These are my two products. Choose whichever one you want. There you go. Sorry?
Pretty sure there might be more than that.
I'm sure. Yeah, but this is an oversimplified version of it. What I'd like to see is for an investor, whether you're going through a mutual fund or a pension fund, at least the option where I can choose whether to go non-ESG or go via ESG. I think that sort of simplifies a lot of things, doesn't it?
Yeah, and given that you have a proper regime to disclose that information,
yeah,
even if you have different type of ESG products, some more driven to profitability and some others more aligned to like giving back to society and for social good, you as an investor, given the proper framework of disclosure, you already have those options under that assumption, of course. So I'm wondering why, where are you coming from with this proposal of requiring consent rather than just providing a proper framework for disclosure?
If there is already a proper framework for disclosure, consent is implied, right? But the detractors from ESG investing suggest that the moment you, irrespective of whether you've told people or not, whether you've disclosed or not, the moment you use any factor other than a sole interest, financial interest benefit factor, you're automatically violating fiduciary duties. And that is where the debate lies, really. Yeah?
Thank you.
I think Virginia has one last comment.
Okay.
No, that's okay. We can talk offline. I was just going to say that I think there's a lot of one suggestion that might be to think about how do you take consent down the investment chain, because I think there's been some conversations to Gen's point about how can we help like large pension funds at the state level that have been very active institutional investors, at least in the U.S. context. But there's been criticism, like, do they really reflect the views of their beneficiaries? And I think with technology now, it should be pretty easy to figure out, do they reflect the views of their beneficiaries, and maybe should there be beneficiary consent? So I think there's some discussion around those possibilities, and I think that intersects really nicely with your focus in your paper, and so that might be something to look at from a comparative standpoint.
Right. No more questions. That's my turn. Okay. It's my fiduciary duty to give you the first shot. No, not yet. Okay. I do think I have a fiduciary duty, okay, so not to put my questions before yours. Now, I think I really appreciate your presentations and all those comments. Well, I think Well, I agree, almost all you have said, but I think there's one more thing I would like to add about the informed consent and the choice. Now, we probably also need to distinguish between how should I term this? New project, okay, and ongoing project, okay? So if it's a new project, let's say it's a new company or being new fund, and if you say this is a ESG fund and you buy it, then that means you agree to that. Then you cannot complain about why you do ESG. Company the same. If the company constitution says we are going to pursue ESG goals, blah blah blah, okay, then the situation should be a bit different if the company or the fund, change the policy in the middle. For the fund, I do not know, but for the company one, actually this may relate back to what I discussed in the morning. So let's say 3 of us set up a company, and now Virginia is the biggest shareholder, and now is a big fan of ESG, and now you want to pursue this ESG goal, but I do not agree with that. Then I would like to, I want to exit, and then there will come the appraisal issue, right? Should this be allowed? Because I do not want to be in this company anymore. This is a fundamental change, right? So my question is, would this be regarded as a fundamental change, which is eligible for appraisal remedy?
Yeah, it would. It would amount to a fundamental change in how the company is being run. And I would suppose a mandatory bid rule might fix it.
Although we don't have that in Delaware.
We don't have that in Delaware, but you could use a mandatory. So if Virginia is going to make fundamental changes to the company which we don't like, let her bid us out.
Okay, so this one will be the new item in the scope of fundamental changes, right? Then it also goes back to my earlier question. So how should we define these fundamental changes, right? Which is eligible for appraisal remedy. All right, I have no further questions. Now it's your turn. Okay.